Judicials, and I'm the vice chair of Alaska Common Ground, and I just want to thank you for joining us this evening and welcoming you to tonight's discussion on Alaska's judicial system with Alaskans for Fair Courts. And Jess, were you going to start showing the slides? Wonderful. As many of you know, Alaska Common Ground, we could not do the work we do without the support of our members and donors. And so if you'd like to support events like this, please consider either becoming a member or making a donation on our website at alaskacommonground.org. Alaska Common Ground, we were founded in 1991 as a nonpartisan organization focusing on bringing Alaskans together on Alaska's greatest policy issues. And we believe that democracy depends on citizen participation. And so I really believe that tonight's event perfectly aligns with Alaska Common Ground's purpose as we welcome Alaskans for Fair Courts. Alaska has a nationally respected judicial system, and our esteemed panelists tonight will educate us on not only the quality and integrity of Alaska's judiciary and its independent judicial selection and retention processes, but also the serious threats and risks that Alaskan courts face and what we need to know and what we can do. And so before I introduce our panel, I want to go over just a few logistical details for folks. Panelists are going to present for about 30 to 40 minutes, and then we will address questions at the end after that. And all of the questions will be in the chat feature of Zoom. So we will be moderating those. And as you may have noted, that the event is being recorded. So in case you or your friends want to watch it later, you can do so. And we intend to run no later than 7:30. And so now I want to introduce our panelists tonight. And before I do that, I just want to say that I'm deeply honored to be introducing each of them tonight. And the first panelist I'm going to introduce is retired Judge Elaine Andrews, who served as a trial judge for over 20 years in Anchorage. And she served as presiding judge of the 3rd Judicial District from 96 to 2002. Prior to assuming the bench in 1981, she was an attorney serving in both the public and private sector, practicing criminal and civil law. And she's a member of the Committee for Fair and Impartial Courts for the Alaska Bar Association, and has a grown family of 5 and enjoys her retreat in the Wrangell, St. Elias area with her husband of 43 years. The next panelist I'll introduce is Donna Goldsmith, who is a co-chair and president for Alaskans for Fair Courts. She previously served as special assistant to former Attorney General Bruce Botello on matters involving state and tribal relations, staffed the Alaska Rural Justice and Law Enforcement Commission for several years, served on the board of the ACLU for Alaska for 9 years, including as president, and chaired committees within the National Council of Juvenile and Family Court Judges. She trained tribal and state judges throughout the country and consulted on development of several tribal courts in the US and Canada. And our final panelist was Tom Begich, who is a strategic consultant and former member of the Alaska State Senate, where he represented Anchorage's District J and served as minority leader from January of 2019 to January 2023. Tom owns and operates CW Communications, a consulting and facilitation firm, and is the senior strategic advisor to Alaskans for Fair Courts. And so with that, I think it's clear that we have some incredible people to help educate us on this topic, very important topic for Alaska tonight. And I'm going to turn it over to our panelists.
Thank you very much. I think that I'll start the program. We really appreciate this opportunity. And one thing I just want to clarify is that Judge Elaine Andrews is not a member of our board of directors for Alaskans for Fair Courts. She is operating independently, but because of her extensive knowledge and presenting background on these issues, I asked her to join us. So I just want to clarify that so there aren't any misunderstandings. I'm really pleased to be here to talk about our work. Alaskans for Fair Courts has an important mission, and that is to protect the judiciary in Alaska, state judiciary, against attacks that are unwarranted, political attacks in particularly. We're here because we have been monitoring nationwide attacks on the courts, state courts across the country. And we know that their frequency and the amount of money being thrown at these assaults are increasing, and they've landed here. We believe that we have one of the finest systems in the country. I think that that has been borne out and that it is at risk. And it's important that Alaskans become better informed about our judges and how they are selected and then retained, so that when Alaskans are asked to vote for judges in general elections, they're familiar with what they're being asked to look at. Courts in Alaska, state courts in particular, are the bulwark against that protect against attacks on the rule of law. And we all know that without the rule of law, society disintegrates. So we have an incredibly ingenious checks and balances system that create a firewall between partisan politics and the judiciary. And because of this system, it's generated very high quality judges over the years. They have focused, the choices of judges have focused on their integrity, their fairness, their impartiality, and the fact that they are capable of putting their partisan or personal beliefs aside and rendering decisions that are not based on partisan politics, which is really, it's a gem. It's something that we need to protect. So we know that that our state courts are under attack in Alaska, both from actors within Alaska and from actors without. These attacks are multi-pronged. They've been direct on the constitutional judiciary article, which you're all probably familiar with, given your interest in civics and engagement. And you know that that attack on the Constitution was beaten back. There are also attacks on social media, bots that are disparaging the integrity of our judiciary writ large. They are spreading incredible disinformation, and it's not just bots. We know they're individuals as well. We don't really know where they come from or who they are, but we know that they're out there. We see it every day. There are targeted attacks on individual judges. You've seen recently a particular judge who's come under assault because an opinion that he issued following the law was unpopular. That is not an uncommon rationale used for attacking judges. Sometimes ideologues attack judges because they think that they are too liberal and that they don't reflect the personal ideology of the people who are attacking them. There's a general lack of respect that is growing, and there's also been an attempt to alter the Judicial Council itself by altering the makeup and making it's more partisan in nature. So these efforts are potentially very destabilizing and really concerning to us because they disrupt the application of the rule of law. It's important that we are asking all of you, after you learn more about this system, to share what you've learned and to encourage others to share them. And our website will offer all sorts of information for people who want it. We've also got a newsletter that we just started. Anyone who wants to receive that newsletter, who's not already doing so, can email me and let me know. We can provide the email later. But the thing that's most important to know is that we've got 19 judges on the ballot this year, statewide, and we've got 15 judges in the 3rd Judicial District. The 3rd Judicial District, as many of you know, is composed of 2/3 of the state's population. That's a pretty large percentage of the population. Yet over the last 24 years, there's been a downward trend, a downward trajectory in yes votes for judges. So Tom is going to discuss that at some point. First, though, I've asked Elaine Andrews to discuss how judicial applicants are kind of vetted and move through the system and then ultimately maybe appointed, and how judges are evaluated once they are sitting on the bench. They come up for what's known as retention periodically, and she's going to explain that process as well. So with that, I will turn it over to Elaine, and then we'll take questions later on. Thank you.
For letting me join in this conversation. It's unusual to be looking at a screen and not be able to see anyone. So I'm going to do my best. I am a fully retired judge, and therefore I am much freer to speak than other judges who are either active, who really cannot speak for themselves, or even judges who sit pro tem, which means judges who are retired but are available to work for the court. I was an active judge for 22 years, and I've been a pro tem judge for almost that same period of time, but now I'm a fully retired judge. And I'm here to talk about my own personal experience and my knowledge of the system that I think is critical that people understand how lucky we are to have it and what we could potentially lose if it should go away. So we have what's called a merit selection system. It's devised on it's called the Missouri Plan, and it was picked by the very wise people who attended our constitutional convention. And the benefit, of course, for those who were trying to figure out how best could we put together a court system is that, Alaska came into the Union in 1959. So they had the ability to look at all of the other systems that existed in the other states. And of course, most of the congressional delegates or the constitutional delegates had come from other states where they saw the fault in the other systems. And one of the things they were very clear about was that electing judges was not the best way to keep judges impartial, that judges who had to run for election had to collect money and were beholden to the parties who either who supported them. So they came up with this merit selection system that is incredibly intense and extremely good at trying to select, as the slide suggests, the best available timber. I'm going to explain to you how that system works, and then that's a system of application, vetting, and appointment by the governor, but the public is not left out of this process at any stage in the process. The public participates on retention elections, but the public is invited all along the way, from the very beginning of the process of appointment all the way to the decision-making that you make when you go into the voting booth to vote as to whether or not a judge should be retained. So when there is either a new judgeship created or there's a vacancy that's created because a judge has died or retired, the application process is open to every Alaska lawyer who meets minimum qualifications. When I first applied for the district court judgeship in 1981, I think that was the first year, or maybe within a year or two, of when district court judges were actually required to be lawyers. Prior to that, there had not been any requirement that a district court judge be a lawyer. But by the time I applied, that had gone by the wayside, and the minimum qualifications were active practice of law for 5 years and being an Alaska resident. So each level of court has different requirements of service. The district court is the lower court, and that has the least demanding requirements. It's 5 years of active practice. And then the next level up of court is the superior court. So those are both trial courts, the district court and the superior court are trial courts. Then we have the Court of Appeals, which handles criminal appeals, just criminal. And then we have the Alaska Supreme Court that handles everything else, all of the, including criminal appeals that go from the criminal court to the Alaska Supreme Court. So each level of court has its own minimum requirements, but they all have the same judicial application. And let me suggest to you that no one decides on short notice that they want to put in an application, because the application itself is incredibly deep, incredibly time consuming. It's about a 25 or 30 page application. And it's highly detailed. It's a little bit like, I don't know, applying for clearance at the White House. I mean, you have to give every address you've lived at, all your employers. They do a credit check. You have to list the recent cases you've been involved with and the attorneys who are on the other side. And so it's a daunting prospect to even fill out the application. And once you do that, actually there are many more hurdles to pass. The most important hurdle, I think, is the fact that if you apply, you are going to be subject to a bar poll, which means that your name will go out to all of the lawyers in the state, and they will rate you. If they know you or they've had any professional experience with you, they are going to rate you. And unlike unlike being a student where you have a pretty good idea of the grade letter you're going to get by the end of your semester, because you've been taking tests and you have a pretty good idea. When you're a practicing lawyer, and that is an adversarial system, so there's always an opponent that you're arguing against. You really don't know what your professional reputation is in the community. So it's a big risk to put your name in and hope that you are reasonably well rated by your peers. So that public report card then is public. If you want to see the public report card of any judge, you can go to the Alaska Judicial Council website and you can see the results of the bar poll. Now, lawyers who apply for judgeships are subject to the bar poll, but before it's made public, if you really bombed out, you can just withdraw your name. You don't have to go through that public process and you can withdraw. But if you decide to stay, then that becomes a public. Then the Judicial Council holds public hearings and invites public comment on people who have applied for a judgeship. And the Judicial Council travels to the community where the judicial vacancy is, and they interview all of the applicants for that judgeship. So you're rated, you are required to attend an interview, and the Judicial Council also solicits general comments from the public. Anyone can write a letter, anyone can show up at a hearing. The Judicial Council really wants to know and include everyone that they can to learn as much about this applicant as they possibly can. Then the Judicial Council meets and they have to send at least 2 names to the governor for the judicial vacancy. They can send more, but they must send at least 2. And, there are certainly races where all of the applicants are reasonably well qualified, but they don't send up the entire group. Their job is to select the best timber, not just the people who are merely qualified. So, it depends on the vacancy, how many names the governor might get. Occasionally, especially in our rural communities, sometimes there aren't 2 qualified people who've applied. People have applied, but the Judicial Council determines that they're not reasonably well qualified, and so they have to re-advertise that position. Sometimes there are 15 or 20 applicants, and they might send up 6 or 7 names of the top merit people. Now, those people are not always the top vote getters of the bar poll, although there certainly is a correlation. And then the governor is required to select from that group of names. And from time to time, it has happened that governors are reluctant. They want another name, but that's not what the Constitution allows. And so they're required to select from those names. Once the judge is appointed, once again, depending on what level of court you're appointed to, then after a certain period of time, maybe a year, maybe 18 months, maybe 2 years, you must stand for retention. And so your name comes up, your retention year occurs whenever it occurs. And you must tell the Division of Elections, yes, I intend to stand for retention. And then the Judicial Council starts this whole process all over again. Another bar poll. And by now, of course, you've been sitting for a while. So now they want to know from all of the jurors who've been in your courtroom, what do the jurors think about you? They want to know from law enforcement who's had contact with you, what does law enforcement think about you? What about probation and parole? What do the court system employees think about you? What do the social workers and guardian ad litems, the people who work with families and children in need of aid and children in the juvenile system, what do those people think about you? So it's a really vast data collection effort, and all of that is put together. And once again, there are public hearings. If anyone wants to tell the Judicial Council what they think about a judge who's up for retention, they hold hearings, they solicit and welcome letters. So there's an enormous packet of information that the Judicial Council gets that they review on each judge up for retention. And they vote on the judges for retention. Should the judge be retained or non-retained? The Judicial Council, I'm just for information's sake, the Judicial Council has recommended all the judges who are currently on the 2024 ballot for retention. So every judge, and as Donna indicated, I think there are 19 statewide and 15 in the 3rd Judicial District. They've all been recommended for retention. So it's a little bit daunting for voters to go into the voting booth. And when they get to the end of what they thought they were voting for, they see this, especially in the 3rd District. And the 3rd District is an enormous district. It's, yes, population-wise, 2/3 of the state, and area-wise, it goes out the Aleutian chain. It goes as far down as Cordova. It's the Kenai Peninsula. It's the Matsu Valley, it's Valdez, it's all of those areas. So we have judges sitting throughout, and I can tell you that I don't know who those judges are. And I am quite confident that most of you will not know who those judges are. So then you get to the end of your ballot and you say, I don't know who these people are. I mean, these are Kenai judges, these are Matsu judges. This is a judge out in Dillingham or Homer. I don't know who they are. And people tend to default to, I don't know who they are, therefore I'm going to vote no. And this is a problem because a no vote means do not retain this judge. The no vote doesn't mean I don't know them. So I'm always encouraging people, finish the ballot. Obviously you can make your own decision about whether you want to vote to retain or non-retain a judge. Vote yes to retain, no, not to retain. And if you are really interested in the topic, you can go to the Judicial Council website and look at every judge up for retention, look at every single piece of information I've just talked about. You could go take the Homer judge and find out what the social workers think about the Homer judge. You could take the Dillingham judge and find out what law enforcement thinks about the Dillingham judge. There's a vast amount of information available for people who want to know. And for people who say, I don't have the time, I don't have the interest, I would take confidence in the fact that the Judicial Council has done the work for you. And they are in this election cycle recommending retention for the judges that are on the ballot. They don't always recommend for retention. And generally speaking, you will know if a judge has not been recommended for retention because it is a big darn deal and there's a lot of publicity around that. For the people who sit on the Judicial Council, I should explain that there are 3 lawyers who sit, and they all have a 6-year rotating term. So they're on for 6 years. That's meant to kind of stagger the ability of any one governor to stack the council. So the lawyers come from Southeast, South Central, and then the Northern District up by Fairbanks. We have the Bar Association makes sure there's geographical diversity. The lay people cannot be state employees, and there's an attempt to make the selection from the geographical regions of the state, but that doesn't always work. Everyone volunteers, nobody gets paid. It is a huge job. They meet quarterly. And I can tell you, because I have been in, having applied for a judgeship twice and having been interviewed twice, I know what sits in front of them. And they are enormous volumes of binders on all of these applicants, because they get all the information. They have to sift through it because they have to interview the candidates. So it's an incredible amount of work that all of the members undertake to try and do this selection and retention process as carefully as possible. So that is the general overview of that. I also want to just take a minute or two to explain, and I know this group probably knows, but I'm going to state it just for clarity. This is not how the federal system works. State judges are merit selected and serve for a term, and then they're up for retention when the public has something to say. Federal judges are political appointments, and I don't want to in any way demean that we have some exceptionally fine federal judges. Many of them have come through the state process. They've been vetted as state court judges, served with distinction in the state court, and then went on to the federal courts. Their appointments are for life. They don't stand for retention. State judges are required to retire at 70. I am over 70. I am retired. I would be required to retire even if I wanted to continue to serve. And all of the judges in the state of Alaska are subject to the Judicial Conduct Commission and the Code of Judicial Ethics, including our Alaska Supreme Court. So unlike the federal courts, where I'm sure all of you are aware of kind of the hoopla that's gone on with the US Supreme Court, and they were not subject to the same ethical requirements as the other federal court judges were, and that has changed somewhat recently. But that's not the case for Alaska judges. And we have a Judicial Conduct Commission. I served on that for 20 years. We are, I'm very disappointed by what I'm reading in letters and on postings, social media about, the corruption of Alaska judges. I mean, we have an incredibly well-vetted judiciary. We have a highly focused conduct commission, and the notion that the Alaska judiciary is riddled with corruption is a very foolish notion. So this is a system that it is really the envy of all of the other states. It's been held up as the gold standard for judicial selection and retention, and it is worth knowing about and being careful to preserve it. So that's my 2 cents.
Well, I'm up next, and I'm having some difficulty here with my internet, so I'm going to go off camera while I talk. It is not a canned presentation. It's still me. So what I'm going to talk to you about is generally what we know about how we vote, some of which you've heard from Elaine and some of what you have heard from Donna. I'm going to talk about some research that's been conducted by AFC and by others. And then I'm going to talk about why it matters. And I'll do this all in a very short presentation, because what is important for you to know is really the answer to the questions that you may have. So let me just start out by talking about what we generally know. What we generally know about the process, and none of this is in the PowerPoint, so don't worry about that. You'll pull the fourth one up in a minute. You'll pull up the graph, but What we know generally is that what Judge Andrews just mentioned, which is that we often don't know who the judges are, and that can be even the most sophisticated voter out there. For example, I've been called in the voting booth from the voting booth by my family members who've asked me which judge they should or shouldn't vote for. So we've all had that experience, I think, at some level or other, or we've been the person making the call. I've had to make the call from time to time as well. So we know that there's already a lack of knowledge about these folks that run for retention. We also know that when we look at the data, there's significant fall off. That is, when people go to the polls and they vote for the president, or in a non-presidential year vote for a statewide candidate like governor, by the time they get to the judges, they just don't vote at all. And we know that because we can look it up and see it online. So, for example, in the last presidential election year, similar to this year, there were 361,000 voters, of which only 318,000 took the ballot for judges. That's a fall off of nearly 20%. That fall off in 22 is compounded the 2 years later by it being a non-presidential election year. So the overall number of people voting was 100,000 fewer Alaskans, and even 100,000 fewer voted for judges. So in that election, the total number voting for judges fell from 318,000 to 267,000 people. So that also reflected about a 20% fall off. But when we did a deeper dive at Alaskans for Fair Courts, we realized that that number in the 3rd district had fallen even more. Over 23% of those voting in the last election did not choose to take the ballot in the 3rd judicial district for judges. That data was further compounded when we looked at work done by the Ship Creek group, and they are also advising Alaskans for Fair Courts. They looked at self-identified ideological perspective. And in that self-identified ideological perspective, while, as we might expect, there's a little bit more skepticism on those who identify as conservative, so a higher propensity to vote no on that end, there was still a high propensity on the other end of the spectrum to vote no as well, though both of these in past elections have been relatively low. The difference is that when you look at those who actually don't vote the ballot, it's about the same whether you're a progressive liberal or a conservative person on the right, whatever you might be, your propensity to not vote that last piece of the ballot is quite high, and it has ramifications. If we know this, others know this. And so consequently, one of the things we noted, and now if you'd put up the 4th page of the PowerPoint, I think the graphic, Jess, if you could do that. There it is. So these 3 trend lines, you can see some faded lines in the background, but these 3 trend lines reflect the 3rd judicial district's voting patterns and the pattern for the Supreme Court. And these are the pattern of no votes. So I'm going to talk about the no vote for a moment here. You can look at the very light items and very light items between the 70th percentile and the 78th percentile. You'll see all the light lines that generally go across the board. They're generally about even. You'll note then with these lines, the darker lines, that they begin to slope down starting in about the year 2004, and they begin to slope precipitously after 2012. Those represent the number of people that are voting no. Voting yes on the ballot. So the number voting no is going up, causing those lines to come down. Only significantly, measurably in the 3rd. We've been able to correlate that voting pattern to increased political activity that has occurred in the elections process. So we know that there's influence happening that is discouraging. But what really caught our attention was this. Each judicial district of our 4 is made up of course, a number of state, House, and Senate districts. In the 3rd judicial district in the last cycle, for the first time in the history of the state, retention votes for judges, all judges, fell below 60%. Remember what Elaine said about it being the largest district in the state. It literally represents 15 of the 19 judges on the ballot this time are coming out of the third judicial, 16. I'm seeing a shake of the head from Donna. Donna, what is the number?
There are actually 11 judges on the ballot in the third judicial district and the 4 statewide justices and the Court of Appeals. So it's a total of 15 that will be on the third judicial ballot, but only 11 sit in the third judicial district.
Fair enough. What I'm describing here is that every judge that was on the ballot, including the Supreme Court, Court of Appeals in the last election, every one of them fell below the 60th percentile. And in this election, that we're hoping that pattern doesn't repeat because we're doing this educational campaign and these kinds of efforts. What we mean is that we want to make sure people are drawing the ballot and then doing the deep dive and research. Here's the other piece to that really caught our attention in terms of the fall off issue. In 5 of the state house districts contained within the third judicial district, every judge on the ballot lost. In other words, fell below 50%. So why does this matter and why should you care is the last piece of this part of the presentation. And it matters for a number of reasons. For the reasons Donna brought out and talked about, where 95% of all of our issues effectively end up in our court system. It doesn't matter about your legislative, in the long run, even your legislative issues end up in the court system for the most part. This is the final place of appeal for all of us. It is a matter of how we perceive fairness in the state of Alaska as well. That matters to how people look at fairness. So that is a critical piece. The third piece is it affects what Elaine talked about, the rigorous process that people interested in being judges and then being retained as judges, the rigorous process that people have to go through is already tough enough. But a judge doesn't have the ability, unless they're directly or personally attacked, to actually run a campaign for retention. They have to, if they are attacked, they can. But until that happens, they can't. That's part of both the beauty of our system, but also one of its challenges, because we end up with a situation where there's no defense. A judge has to mount a defense at the very end of the process. And so it's imperative that people become well-informed in the process. We must reverse the trends that we're seeing, the trends of fall off on the ballot when people simply don't choose at all to vote the ballot, the trend of lack of information that our voters have about who the judges are, and then finally restoring faith in the system, a very well-constructed system, as Judge Andrews outlined, a very well-constructed system that encourages people of the highest timber to want to be judges. It will discourage people if our process begins to break down to such an extent that these become no more than political campaigns. And so that's why we're here before you today. That's why we're talking to you about our faith in the system and our interest in getting you engaged in the process. So with that said, I would open this discussion up to questions people may have in the chat, and I'll leave it to our moderators to ask those questions. But it is imperative that we all get engaged. I hope you were able to hear that presentation.
Yeah, thank you very much. And thank you to Judge Andrews and Donna and to Tom. We do have a few questions and some comments in the chat. And just a reminder, if you have some specific comments or comments specifically about our judicial selection and retention process as it relates to the presentation here for Alaskans for Fair Courts, please put those in the Q&A. The first one I'm just going to pose to the panelists is, someone asked, how is the public informed of opportunities for review and comment on selections and retention? So it's like a notice kind of thing. How does the public even, how are they even made aware? And then kind of the second part to that is there typically much general public involvement in that?
Elaine, do you want to take that?
Yeah, the judicial elections are really quiet. I mean, I'm always telling people, you're not going to see signs in yards. You're not going to see people waving placards because of what Tom described, which is that ethically, judges are not allowed to do any political activity well, at all, but if you're a sitting judge and if you are affirmatively attacked, then you can respond. But the people who attack judges know that. So they wait until, you know, a couple weeks before election. They've bought up media, they have their graphics ready to go, and they unload right before the election. And then the judges who are, you know, who by definition have not been and cannot be politically active, are left to kind of fend for themselves. And so because these are quiet elections, it's kind of hard to find out about, you know, how can the public participate. So I will tell you that the Judicial Council puts public notices in the newspaper, and on their website, they say, you know, we're having a public hearing about judges up for retention. Here's the date and time. So, you know, they're a state agency. They're not, they don't have enormous budgets to publicize things, but and to be honest, there isn't a whole lot of public participation because these are quiet elections. There's rarely controversy. Rarely are judges recommended against for retention. And if there's opposition, it comes low and it comes fast. And the Judicial Council will have already made their recommendations by that time. So it's quite different than any other political race. I have to say that.
And I'll add to that, that the reason that Alaskans for Fair Courts exists is to address this problem. It's why we came into being in 2020, because 9 judges, including a Supreme Court justice, came under attack. And the attacks were just fairly ridiculous, to be honest. I can't think of any other way to describe them. And we organized fast and furiously and pushed back. We, as a general rule, don't start addressing judges who may come under attack until they've actually come under attack historically. But in this election, we know 3 judges are already under attack, including a Supreme Court justice. We know that. So we are preparing, and we have a lot of information that will go on our website. We will push it out through social media. We're sending out information. Many of you might have gotten postcards that we sent out about how judges are chosen, what kind of vetting process, how they're retained. So we're starting to approach this a little differently because we feel like judges are sitting ducks. And, you know, everybody knows if you run a defensive campaign at the last second, you're not as effective. If you shape the narrative and get ahead of the game, you can be more effective. So one of our primary goals has been to educate Alaskans about these processes, get them involved, get all of you to finish the ballot, because that is just critical. We know that there are a whole host of folks that are never going to have faith in the judiciary. That's just life. They don't have faith in public institutions, and we can't change that. Or they're ideologically, you know, it's so ingrained in them that they just can't get behind any of this. But that's not the majority of Alaskans. We know that. We know from efforts that we've made in research. We know that many people want to sustain this court system, and they want it to remain nonpartisan. And the only way it remains nonpartisan is to keep partisan politics out of the selection process and the retention process, and to vote to retain the judges who have demonstrated their qualifications, as noticed by the Alaska Judicial Council. That vetting process is rigorous. It's as comprehensive as it could ever be. And you can find as much or as little information on the Alaska Judicial Council website as you want. You will find some of it on our website as well. We have a drop-down menu where you can go to find my judges on our website and type in your community, and the page will populate with the judges who are on your ballot this year. And then we have links to their evaluations. And you can look at those summary links. If you want a deeper dive, you can take a deeper dive in the Judicial Council website. If you want to look at the summary of what the Judicial Council did, which is an extraordinary compilation of information. I mean, it's just absolutely incredible how much information they gather. Then you can do that. You can look at the summary. You can go into the deep dive. You can find what you want. You can also likely every year, I don't know that it will continue, but we're hoping the brochure that is published for the voters pamphlet will have summaries of whether or not the Judicial Council voted yay or nay. And this year they voted yes on every judge. They got a thumbs up. So we encourage you to get informed. It's the only way that we're going to protect ourselves. We do not want, I've been in a court where a judge was bought. I've been there. It was the only case in my career I lost, and I couldn't figure out, it was not here in Alaska. It was in another state where judges are elected. And it was just stunning to me when I realized what had happened, that my opposing counsel was one of the judge's best friends, and he had not recused himself. And my opposing counsel was also the person trying to adopt the child that I was representing. And we lost, and there was nothing we could do about it. So I encourage you to learn and get educated.
I see some other questions.
Yeah, there's some other questions, and I'm going to go. I know this, someone actually mentioned this, but have you already, or do you know if there's already been a decline in applications for judgeships due to the kind of increasing negative votes and the downward trend? Have we already started to see that fewer people are applying to be judges?
Not yet. You
Not
haven't
yet.
seen it.
Okay.
That's to underscore the point. That's primarily why, I mean, not primarily, it's one of the reasons behind why it's important to get to effectively deal with this now, because you don't want to create a discouraging environment, or you will begin to lose the applications for the best timber. That's a driving motivation. I've spent 35 years working on campaigns and watching, and being involved in the political process, and getting good people to run for office is very, very difficult to do already. And it will only, if this becomes a politicized judiciary, it is going to make it extraordinarily difficult to get the level of competence and quality that we've had to want to go through that process. And Chuck asks the second question, if I may answer that one, which is,
Yeah, no, I was going to do that. Yeah, go
where
for
is
it.
it
Yep.
here? Yeah, where's the opposition appearing? Well, here's where we know it has appeared. We know that it is appearing in social media. We've seen it in social media. We've actually seen it directed at a particular judge already this year in social media. We've seen that. We've also know that there was some direct mail that was paid for and used in the prior election. So that's a different medium, but it's a medium that has an impact. And so we do know it's difficult to track and follow the money to the Public Offices Commission to know where it's being spent, but you can see it is being spent. So that becomes difficult to know what they're buying, but we know that it has had an impact. That much we do know. And we're continuing to constantly try to keep our eyes on that.
And on that point too, and Tom, I think you were the one that mentioned this in your presentation, that a judge cannot campaign basically against an attack until the attack has started. What constitutes, I guess, starting of the attack? Does that have to be some sort, because it sounds like, and Donna just mentioned, there's already some awareness of some judges that may be in that situation in the upcoming election. I guess at what point is that trigger point such that the judge can actually launch a retaliatory attack back?
That's
a tricky question.
It is a little bit tricky.
Because it depends on the call to act.
I think that, Elaine, is the Judicial Conduct Commission correct that makes that decision?
They don't, yes. Well, let me, I just did a presentation earlier today and the same question came up. There's no statutory or rule definition. So the careful judge goes to the Conduct Commission and asks the executive director based on research, is this considered sufficient to be an attack? And so a careful judge asks for basically a ruling from the chair of the Conduct Commission to say, this is sufficient, you're free, you can take the handcuffs off. And so judges really wouldn't proceed without that.
So for example, we know one judge who is the focus of a particular media site has written about that judge and said in unequivocal terms, we oppose this judge. Here's what we think is wrong with this judge. Here's what we don't like about this judge, and we're going after that judge. Well, that's fairly direct. That's a direct attack. So, others may wait. They may wait for the other two, which have come under fire, may or may not be attacked. We don't, in that manner. We don't know yet.
Yeah, there's also the gray area of the website, which, you have a blogger who may say something extraordinarily negative about a judge and remind that judge is up for a retention election. But they're a blogger, they're news, potentially news. So where does that go? That's when I would take to the Judicial Commission, for example, and say, do I have a right to defend myself against this? This person, but it becomes, you can see the gray area, and it really does hamstring efforts to defend.
Well, it hamstrings judges. It doesn't hamstring us. We don't have to wait. We make our decisions based on we're scouring, we read, we listen, we watch. We can do what we want when we're ready to do it. We do not have to wait until a judge is directly attacked in somebody else's.
Yeah, when she says she's Alaskans for Fair Courts, and you may have already received a piece in the mail that we've put out just as sort of a preemptive, you should be aware kind of piece.
And and judges, I have been around long enough. There are judges who have been attacked and decided they weren't going to mount a response and just decided to take their chances. I think the important thing to understand is, judges don't ask to be given these tough questions to decide. I mean, they are randomly assigned cases. The cases they get assigned are issues in which the public in general has been unable to resolve an issue. So, you never get a softball. It's always a tough question. I mean, it may not be very much in the public, but you are asked to decide custody between two loving parents who cannot work it out themselves. You're asked to decide prison sentences. You're asked to decide really tough questions where there is not an agreement. And so you're randomly assigned to these cases. And as I explained to people, in this business, you are a great judge if you could get a 50% approval rating, because someone is going to win and someone is going to lose. And in my experience, the person who wins is pretty unhappy because they didn't win as much as they thought they were supposed to. And the person who lost because you're a bad judge. So this is not a profession you choose if you're looking for personal affirmance. Let me suggest that. But you do take an oath to apply the law to the facts. And there are cases in which you are going to have to apply the law to the facts, and you are going to have to come up with a decision that the public is not going to be happy with, and that it could be the impetus for you to lose your job. And you need to be able to go into this job knowing that you could basically, cut your parachute strings, because if you have to do what you have to do, you're going to drop to the ground and you're going to lose your job because someone was unhappy with the outcome, but you did what you were supposed to do. So judges, it's really a hard situation because you have to make a decision, and judges are rated and judged on whether they are acting according to law, whether they're being diligent, whether they're knowledgeable, whether they're fairly applying the law to the facts. They should not be rated on whether or not you're happy with their decision. So it's tough for people who are trying to fairly vote on judges, and it's tough for judges who are trying to make the right decision. So
But
it's
I'll just underscore that, you know, we think that Alaskans want judges who follow the law, no matter what. That's what we need. If we take out judges every time we don't like a public policy decision, for example, we're just going to be rocking and rolling. The court is just going to rock and roll. There won't be any stability on the court. There won't be any knowledge base on the court. You know, every time you lose a judge who's been around for a little while, you lose a knowledge, you know, a knowledge base. It takes time to learn how to be a judge. You don't just walk out of law school and become a great judge. You might have a great mind, but you have to learn how to be a judge. So if you take out a judge every time somebody doesn't like the policy that ends up being the decision, then there's no end to taking out judges. You just keep taking them out. And every time you don't like a decision, take out another judge. That is no way to have a court system that maintains law and order and provides justice. It just doesn't, it won't work. And it provides constant instability. And I'm doing this work full-time pro bono because I am so deeply committed to this issue. It is so concerning to me what direction we could go in. I can't even imagine having a court system like that. This is just it's as good as it gets. And we have such incredible judges, and we've got to learn to live with, well, we lost, you know, you lost. You move on and move on. And you learn to live with the loss. And then there's another case, and maybe somebody else wins, but that's just the way of the system. As long as we can be assured that judges are looking at the evidence, that they're impartial, that they're nonpartisan in their approach, and they do their best to follow the law, what more can we ask of them? And that's a big ask. That is a really big ask, but it's what we demand of our judges, and we should demand, and we should accept whatever the consequences are if they meet all of those standards.
Yeah, and there's thank you for that. And we've got a few questions that are coming in, and I'm going to try to I guess streamline these as much as possible in the interest of time for us. The first question I think is a pretty bright line answer. I think somebody asked, you know, what percentage of yes votes are required to retain a judge? That's a pretty, I think I know the answer, but I don't want to be wrong.
It's 50% of those who cast it in that particular election.
It's 50. Okay, it's not 50. Okay, so it's 50%.
And it's not 50 of everybody who drew a ballot, because it's 50 of those voting in that election. That particular election. Okay.
And then in terms of, there's some questions regarding election of judges. And I think that word election is interesting. I guess I would argue maybe we don't elect our judges here in the same way as I haven't seen in other states. But can you talk a little bit about, I guess to address this, how we are different than other states when it comes to choosing our judges?
Yeah, let me lay out for you in a report in June of this year. The State Department actually talked about this very issue, and Donna's going to go into the differences, I think, or Judge Andrews will, but partisan elections are held to select all or most state and local judges in 13 states now, and some judges in an additional 8 states. Nonpartisan elections are held in an additional 20 states, while others are appointed by state officials. But in total, about 1/2 of American states hold elections for the judges on their state Supreme Courts. The other half don't. And then in roughly, based on these numbers, roughly 40 states have some form of election at some level, but that also does include retention elections. Those are the nonpartisan elections in an additional 20 states. Some of those nonpartisan elections. So it's a confusing mishmash around the country. But I'll flip it over to Donna and Elaine to talk about the Missouri system, which is what ours is based on, and you heard a little bit about it earlier.
Well-
Elaine, do you want to do it or do you want me to do it?
Well, I'm gonna turn it over to you, but just to say that, and Donna, I hope maybe you have these numbers at your fingertips, but in the contested partisan elections, the numbers that are being funneled into judicial elections are breathtaking. Millions and millions and millions and millions and millions of dollars. And so, I mean, you just think about, as Donna suggests, you walk into the courtroom and the judge who's sitting there is the recipient of millions of dollars from a sector that you are, you're not part of. I mean, how do you feel like you're out, in the starting blocks at a fairly run race? I don't think so. And, there's just no way to have confidence in the system where there's that kind of financial infusion. But Donna, maybe you could talk to that.
Well, in, I think it was Wisconsin.
48 million.
How much?
48 million in
Actually,
just
I think it was upwards of that, actually. I think,
in the year. That there's money that's come in since, but it was
in that particular, there was like one election. I think it went as high as 50%, but I will say that there is a march across the country that is happening. There's an effort being made by people who are much more ideologically extreme than I am, who are attempting to remake state judiciaries across the country. And we're in their bullseye. And we're in the bullseye because we have constitutional protection that they want to eliminate, and because we are a cheap date, as Tom likes to say. This is a cheap state to run an election and to go after somebody.
For $500,000 between now and the end of the year, you could own the airwaves. And when you're talking sums like these people invested $3.5 million 2 years ago in a Montana Supreme Court race, $7 million this year. It's chump change to buy Alaska.
3 million in Montana.
How much now? Where are they at now?
3 million. The judge who was the justice who was under attack a couple of years ago was here earlier last fall, and she said they spent $3 million. $3 million for a single race, and we know that number has climbed this year. We know that Kansas right now is looking at beating back efforts to eliminate their merit selection system. So the attacks are happening. There is a phenomenal amount of money. One party has bragged about putting more than $25 million into efforts to take out state judges who are not ideologically aligned. More than 25 million. I don't remember what the exact number is at this moment, but it was at one point a couple years ago, 25 million. And I know that there is a $1.62 billion trust fund that is being used for this effort across the country.
We
So we
Alaska's
have
also been listed as a high
risk.
Go ahead.
High risk at the possibility of losing our judicial independence. And
by one.
I'm sorry, what? I didn't hear you.
I was saying one national group has identified us at the top of the list as a high risk for losing our judicial independence. I was repeating what you were saying.
Right.
Sorry.
Right. So, the money being thrown at this is outrageous. We can't compete with the money, but we could sure compete with the commitment. And that's what we're looking to do. And what we're trying to do is encourage all of you to take this seriously. It doesn't matter whether you liked an opinion that was issued in a court where you had to litigate. It doesn't matter. That is not a good reason to take out a judge. The reason you take out a judge is because they are inappropriate, improper, they don't follow the law, their, behavior is outrageous, their race, I mean, there are all sorts of reasons to take out a judge or to refer them to the Judicial Conduct Commission, better. But we're being asked, the way our system was set up was to ask the Judicial Council to vet the judges who have to stand for retention, and for us to read what they've concluded. And unless we know something extreme that's happened between the time that they recommend a judge and the time that the election happens, we are encouraging people to look at their at the Judicial Council's efforts.
And actually, Donna, that goes perfectly into the question. One of the questions in the chat was actually wanting a little bit more clarification about the Judicial Council specifically in terms of what are the qualifications to, I guess, somebody can talk a little bit more about the makeup of the Judicial Council
Sure.
and how many people are on it and what the qualifications are to serve on that.
So there are 6 members of the council, and then the Chief Justice is the 7th member who votes as a tiebreaker if needed. 3 of the council members are attorneys who have been appointed by the Alaska Bar Association after a poll has been taken, or a questionnaire. I don't remember exactly what the process is, but members get to recommend these 3. And then 3 members are appointed by the governor, confirmed by the legislature, correct? Sometimes I mix that up. So those are non-attorney members. They're called the public members. And initially the intent was that no governor would appoint more than 1 or 2 of those public members, but that's gotten a little bit skewed for reasons I don't remember, honestly. So this governor will be appointing the 3rd Judicial Council member, public member in next year, his 3rd. But there aren't any qualifications for the public members. The intention is that they reflect kind of geographic areas in the state should be represented there. You've got 6 council members, but I don't think right now that that's an accurate reflection, but there's certainly been an attempt made in the past. For example, when the representative from Nome turned off, the hope was that somebody from an extremely remote community would be appointed to the council, and that did not happen. But that's the goal anyway. That's what the Constitution provides. Did I miss anything, Elaine?
No, I think that's fair.
Someone is wondering if Alaskans for Fair Courts is a 501c3.
It's a 501c4. A large part of our work, the majority of our work is education, which is typical of a 501c4.
Okay. And kind of there's several other questions here, and I'm just gonna, in terms of money that's being spent here in Alaska, do we know where that money's coming from? Is it coming from outside, coming from inside, all of the above?
We know that. Go ahead, Tom, you can take this one.
It's mostly outside money, but there's also inside money as well. Yeah, there are a number of organizations that we've been able to track. Americans for Prosperity is a major contributor in the past. We haven't looked at APOC reports from them this year because they're not, depending on their level of activity, they report after year end, depending on whether they're donating their money to a local group, in which case they themselves don't have to report until year end. So, but the local group would have to report that the money was coming from them. We know that there was at least one local group that came into the selection with a substantial donation from late October of 2022 from Americans for Prosperity, nearly 200,000. They dropped on that group at that time. And that group did not have the ability, nor did it report expenditures equaling that amount over the last 2 years. So we know that they're retaining that resource, at least to some degree. So,
Which we assume is going to be spent this year.
and that's the publicly reported money. Not everyone plays by the rules. And that's one of the insidious elements, that bleeds into other issues that are out there. But, dark money is called that for a reason. You can't see it. And, that's one of the conflicts, one of the problems through entities that have communicated these positions. I'm sounding vague because I don't want to say something that it's virtually impossible to verify some of this stuff. But what we can verify are those amounts that have most of the money has come from out of state.
We know where the money came in, for example, in the 2020 election, and there wasn't any money spent that we know of because there really wasn't a contested judicial election in 2022. We ran ads, but nobody actually came under attack in spite of what we thought might happen. But we do have, little bits and pieces of information about what was spent in 2020. Was not a sizable amount of money, but you don't need a lot of money to, run a good social media campaign.
And when you see smoke, which is this significant difference between the third judicial and the 2022 election and everywhere else, and then you follow, the trail of that smoke, and you get people talking about the piece they got in the mail, or the pulpit speech that was made in their church specifically on the topic, you begin to get a picture of it. And why only the third? Well, that's because you experiment where your money goes the furthest, which is, 2/3 of the state's population lives within the third judicial district. So, if you can have an impact there, you can control the courts. You can have an impact on the courts. That to me is one of the most insidious things, is that it's such a below the radar thing that you miss it.
Sorry.
That's why, I talking with Don, I'm like, wow, you are the only people a little bit blocking those efforts in the legislature from the Justice Not Politics group. But AFC is the only group working on direct support of this system and the hard work that's gone into this system at the electoral level.
Yeah, we are the only one at the electoral level. I will say that we know for a fact, because we've read it, that there is at least one major religious group that is made no bones. They've published an article that they are making no bones about going after their parishioners. They are going to be monitoring whether they go to the polls and whether they vote, and they're going to be asking them how they voted. They're putting a lot of pressure on the leadership within that church, and churches that are affiliating with them. And that is another tactic that we know about. I find that really appalling, but I've known people who told me that they vote according to how their pastor tells them to vote, which I can't even imagine doing, but that's what's happening. I would never give my vote away, but everybody has their own choices to make. Hopefully you all don't make that choice and you make your own choices. That's our goal.
Well, and go ahead, Tom.
Oh, I saw, you're going to add to that point, so I'll let you add to that point, but
No, go ahead. I was going to kind of move on to, go ahead.
Yeah, well, I didn't want us to miss Heather Flynn's comment earlier in the chat. And she talked about the impact on education, and that's obviously many years on the school board, on the Anchorage Assembly as well. And she's talked about how the opponents of public education have effectively subverted both legal and regulatory guardrails, and the courts have been unable to rein in their pursuits. I'm going to push back just a little bit to say that, in fact, the courts have been our last recourse in pushing back against these efforts to undermine the public education system, and in large part have been relatively successful. Even in this most recent decision, which reversed a Superior Court's decision that was based on a technicality, and the Supreme Court even asked that it be re-argued with a more effective plaintiff. So you've got a situation here where where the courts have become the last resort in many ways for defending the 60 words of the education clause of our Constitution. And I think it's worth noting that is precisely why this is an important issue, because if we lose that last, as you put it, Donna, bulwark against this kind of negativity, it will be a politicized process. We've managed to make our courts have made very unpopular decisions from time to time based on the law when it comes to education. And I would argue time and time again, they've been correct in those decisions, whether it was Casile, which ensured fairness in how we constructed school buildings, or Moore, which it talked about how we do adequate education. Those were decisions that were really ultimately made by the appeals court, the Superior Court, and on appeal, in some instances, some of the other cases, all the way to the Supreme Court.
I want to add one more thing. I think this is important to note, and that is that Justice Not Politics Alaska, which Tom mentioned, has done a great job in the legislature at holding the line. They really have. They will continue to do that. And they have done a great job in civics education. They're going into classrooms and they are teaching young people what they need to know. It's scary. You know, Elaine was at a presentation recently where I think it was you who told me that someone who was teaching these kids said, oh gosh, I didn't know that the judges on the ballot hadn't done something wrong. I thought they'd done something wrong. So we have a lot of education work to do. There's a lot of misinformation out there, and we are working like crazy with the Fair and Impartial Courts Committee, with everybody who's interested, every speaker who knows anything about this. We are all working collaboratively, Justice Not Politics Alaska, to get the information out there. Tom is correct. We're doing the electoral. We are doing the electoral piece, and we are the only ones.
And I'm
Everybody
always,
else is
I'm
working
interested.
hard.
Yeah, I'm interested in talking to any group that wants to learn
Yeah.
about the topic. So if
And-
you know, if anyone says, gee, I wish my X group could hear this, you know, my hand is raised, because I think public knowledge is the key to you know, the key to fairness. So
And I would just say that Elaine has been a tireless speaker and advocate for this issue for years. And gosh, if we could clone her, we would clone her, because she's remarkable. I mean, she's really, really superb. And she speaks from experience, which is unusual. So yeah, anybody wants to hear from Elaine, you are not going to regret it.
Yeah. I'm happy
Well,
to-
actually, I was going to ask, in addition to taking her up on her offer to come and share her knowledge, I'm also just want to confirm for this group where folks can get information. And I know we've mentioned the Judicial Council website. I know you all have a newsletter. Somebody in the chat referenced the Division of Elections does put something out as well. Are there other places that you recommend folks go to learn more and to share with their friends and neighbors?
There is a website called alaskajudges.com, I believe, that's got some of the same. I mean, there are four websites that have the same information in different formatting. Alaskans for Fair Courts, Justice Not Politics it does not have electoral information, but it does have information about the whole process. The Alaska Judicial Council, and I believe it's alaskajudges.com. I should check that to make sure. And we all have a tremendous amount of information. We have provided it differently. You can get it anywhere. You can go to the, I don't know if the league is going to have they have a newsletter coming out, and they've got a brief article about it. We have a newsletter that's brand new, and we're, like I said, we're taking, you know, want to sign up? I gave you my email in the chat. That's a good way. And there's a function within the newsletter. It tells you how to forward to a friend. You know, you click on this link and you fill in your friend's email. I mean, there's just a lot of information out there. You just have to take advantage of it. And we will at some point, and I'm not going to say when, we will start promoting information about specific judges and about this election. We're not We're not at that stage yet, but we are promoting information about the processes and how it all works. And there will be ongoing information going out. So social media, our Facebook page, it will be ramping up any minute now. Give me a week.
And yeah, thank you. And actually a couple pretty pertinent questions have just kind of come in, and I want to make sure to address these before we get out of time. There's one that someone asked, could you further explain how not voting for the judges is effectively a no vote?
It's not technically, because it doesn't count toward the 50%, but by not voting as an intelligent voter, and everyone on this call is probably a pretty intelligent voter, you are effectively reducing the ability of that judge to be retained if you think you would have been a yes vote based on the judicial recommendation, or for that same judge to be not retained if the Judicial Council had given them a no rec. So you really are effectively taking yourself out of the process. We believe if more people are informed and more people then vote, then we have a really good chance of retaining a fair system that respects the decisions of the council. If, though, fewer and fewer people vote, the ability of using money to affect the opinions of those people and to dramatically change the system goes way up. So it's indirect.
We do have someone who asked a question about the church that was mentioned earlier.
Yeah, very quickly, it's Alaska Family Council, Jim Minery, and it was an op-ed piece he put in the Alaska Watchman. That's literally.
But there's a church behind it. There's a larger church that he's partnering with, that is actively going after voters.
He is actively involved with and has been part of what was once the Anchorage Baptist Temple. It's now called a Mountain View Church, I think, or Mountainside Church. They changed their name recently.
They change it every couple of years. Makes it easier for APOC.
And Judge Stein Kruger, who does some of this talking up in Fairbanks, is a former member of the board of AF, Alaskans for Fair Courts.
Well, as we get close to time here, I just want to, first of all, thank Judge Andrews and Donna and Tom for your time tonight, and for all of you for attending. As you can see, this is obviously a very, very important issue. I think that falls under the radar sometimes, and it can't anymore. So thank you for being here tonight. Are there any final words or any comments from our panelists before we sign off this evening?
I would just say, get informed.
Yeah, and finish the ballot.
Finish the ballot.
Yeah. Get informed and finish the ballot.
That's the message.
Thank you very much for offering us this opportunity. We really appreciate it.
Many thanks to Alaska Common Ground. Thank you very, very much for the opportunity.
And frankly, I won't speak for Tom and Elaine, but I probably could. If anybody has any questions and wants to call me, phone number's on the website.
And thank you all so much. And again, when we do these Zoom events, right, the thing that's missing obviously is the sound of the applause from the people that attended. So you can imagine that. Thank you so much for your time. And again, if you want to support more events like this, you can go to Alaska Common Ground's website and become a member if you're not, or donate there. And we just really appreciate all of you. As we continue to work towards an engaged Alaska democracy. So thank you all so very much.
Thank you.
Thank you.
Bye. Take care.